So far, we've talked about the standard of care in negligence in fairly open-ended terms. We've talked about the standard of reasonableness, reasonable care in the circumstances. But what's reasonable may, of course, vary between persons. Some people think this is a reasonable way to act, and others may take a different approach. And in practice, this is simply decided by the judge in deciding the case. We can see that the judge will bring his own experience probably to the case and decide what he thinks is reasonable. But we have something to go on so far. We know it's reasonable care in the circumstances. We know it's objective. We know it disregards the defendant's characteristics. And we know that there will be some exceptions of children, mentally infirm, and physically infirm perhaps. But nonetheless, it's all rather vague. This means that it will be hard to predict the outcome of cases, which is just how it is. There's not much one can do about that. The more experience you have, the more likely you will be able to predict the outcome of a case and how a judge would respond to a certain set of facts. But there is a slightly more disciplined approach that we can take to certain kinds of cases. There are some principles, really almost economic principles, that can assist the court in determining whether or not reasonable care was taken in the circumstances. Reasonable care has to do with risk. Now reasonable care, when you think of it in the context of risk, is maybe easier to understand. If I do this activity in this way, are there risks? And are the risks very big? Are the risks very tiny? If the risk is very tiny, then perhaps it's a reasonable risk, one that can be taken. After all, almost all activities involve some risk, but some involve much more than others. So if we think about the concept of risk, which is really what informs the standard of reasonable care, then maybe we can make a little more sense of it by looking at some of the cases where the judges explicitly talk about risk. And there are a few factors, a few explicit factors that may guide the court in its reasoning. First of all, we have when a defendant is engaging in an activity, we might say, well, what is the likelihood of a risk of injury occurring? What is the likelihood? And, in ordinary activities, we can only have a general understanding of what might be the likelihood. For instance, let's say you're a pedestrian and you're crossing the street. And it's a controlled crosswalk and the signal is red. So you're supposed to wait. But instead, you see that there's no traffic, so you think, well, will I cross the road or should I wait? Maybe it's a reasonable risk. I can cross the road, there's no traffic. Well, you can decide whether you think that's a worthwhile risk to take, but we can see that there is a risk because the traffic will have a green signal, and the traffic, if it does come, will come right through. So this is a real risk. One might say that the likelihood of an injury occurring when you cross through a red light is fairly high. And then if we consider if you cross through the pedestrian crossing when it's green, the risk of an accident is fairly low because you're going to go through and it's green, it's red for the traffic. So we can see how it varies. So in many activities, we can sort of stop the clock and examine what is the risk here. And when we look at the case law, we see it in clearer terms. So the case of Bolton and Stone articulates that principle fairly clearly. The plaintiff was injured when she was struck by a cricket ball that was struck out of the playing field by a batsman. The batsman was probably a pretty strong batsman. Nobody expected the ball to go outside of the playing area into the street, but it did, and the plaintiff was injured. In determining whether the cricket club was in breach of duty by playing cricket on that field, the court examined the likelihood of that accident occurring and came to the view, after examining the records of the cricket club, that the risk of that happening was very small because it had only happened 5 times in 30 years. This means it very rarely happens, and therefore the court said, given that the risk was so low, then it was reasonable to play cricket. And this is interesting because, of course, from the plaintiff's perspective, she was injured. She would expect to get compensation. But remember, you only get compensation if you can prove the defendant was at fault. And the defendant here is not at fault, according to the court, because it was reasonable to play cricket because the risk was so low. And here you can see, this is a way of understanding what is reasonable care. How likely is the risk going to be. On a related theme, we can talk about the seriousness or the gravity of the risk if an accident occurs. So this is related. These concepts are related. Here we ask the court asks the question: if the defendant engages in that activity, and there's a risk of an injury occurring, well, if the injury does occur, will it be a very grave or serious injury, or will it be very minor? And where the court finds that if the risk eventuates that the injury is likely to be serious, well, then this means that it's even a greater risk that the defendant is taking, and perhaps he shouldn't take it, or he should adjust his behavior so that he lowers the risk, the likelihood of the risk occurring. And if I put this in rather blunt terms, well, on the one hand, you have the Paris case in your book, where the court applied this reasoning. In that case, the plaintiff was a workman who was blind in one eye. And he was working on machinery, on metal that he was banging, but he didn't have any safety goggles. Now here, if you are working without safety goggles and you are blind in one eye, this means that if you do suffer an eye injury, you are totally blind. And this is what happened. The plaintiff did suffer such an injury and became totally blind. And here the court, applying the principle, said that the employer, the defendant employer, should have applied more care in regard to this worker because he's blind in one eye already. Of course, perhaps this means that if you were dealing with another worker who was not blind in either eye, had two good eyes, maybe the standard would be different. So again, here, this has to do with the seriousness of the injury should an injury occur. And by way of comparison, if I just make something up, you can imagine this is a case of a workman, or you can imagine with Bolton and Stone a case of a heavy cricket ball. But imagine now that the sport is badminton, and the badminton shuttlecock is struck out of the court and it lands and hits someone. Well, what is the likely gravity or seriousness of the injury should that happen? And we can see it's going to be a very minor injury, if any injury at all, because it's only a light shuttlecock. And that means that a different, perhaps more relaxed standard of care would apply in regard to that activity. You can go ahead and play badminton even when people are in the vicinity, because even if they do get struck by the badminton shuttlecock, nothing much will happen. This makes it, I think, for a comparison with something like Paris or even with Bolton and Stone. And yet another related concept has to do with, they're all connected, again, I remind you, it has to do with the difficulty of eliminating or reducing the risk in question. If it's easy to reduce or eliminate the risk, then the defendant should do so. And the case of the Wagon Mound demonstrates that. I'll leave you to read the case. I won't even bother going into the facts of the case. The principle is simple. If the defendant's activity gives rise to a risk of accident and injury, then whether or not he's in breach will depend on a number of factors, including how likely that risk is, how serious the injury would be if the risk eventuates, but also how easy is it to overcome the risk. It may be very easy, as it was found to be in the Wagon Mound case. How easy is it? Depends on the nature of the activity. If you go back to Bolton and Stone, the cricket case, how could you reduce or eliminate the risk of someone being injured by a cricket ball? Well, you could change the rules of cricket and say you can't hit the ball hard, but that's not going to work very well. Or you could build a higher fence and have, so that the ball is less likely to go out. But of course the ball still might go out. I guess you could build a covered stadium, a domed stadium. That will certainly solve the problem. But then the court would ask reasonably, is it really worth it? Is it worth it to go into all those expenditures when the likelihood of the risk occurring is so tiny? So weighing these together, we can find that we can see how the court reached its decision in Bolton and Stone. Although if a cricket ball hits you, that could be a serious injury, but it's so unlikely to hit anybody, and it's so expensive to eliminate the risk that at the end of the day, the court comes to the view it's reasonable to play cricket on this particular cricket ground. And then we have yet another factor to mix into this analysis, and this has to do with the social justification for taking the risk. It might very well be that the defendant is taking a risk, knowingly taking a risk. It could be fairly risk that is of a high degree of likelihood, or even one that might produce serious injuries if it occurs. But there may be a social justification because there are other social goals being pursued. In the case of Dayborn, involving in wartime the use of a ambulance with imported from North America with the steering on the wrong side is an example, and I invite you to read that. But a more concrete, immediate example that I can just make up right now has to do with ambulances in Hong Kong. You'll often see that when an ambulance is driving through the streets of Hong Kong, it does not abide by the traffic rules. It will go into the wrong lane, go through a red light, do all these sorts of things. Of course, when a motor vehicle is going through a red light, there are obvious risks being created. The likelihood of an accident is even greater, and the consequence might be grave because there would be another motor vehicle accident. But nonetheless, if there is an accident, the court may very well forgive the ambulance driver because the ambulance driver has a higher goal to pursue, save the life of a person who's in danger. And so this is really a concrete example of that principle. But bear in mind, all four of those, let's say, concepts or factors that I've just discussed are in the mix together. They don't really operate in isolation. In any given case, the court would consider all of that. And I should remind you that in most cases, the court does not consider any of this because the facts do not provide enough information to engage in such an analysis. A car driver who is distracted by his friend who he sees on the pavement as he's driving by, who simply loses attention for just a second, is not making these sorts of calculations. He's just responding as a human being to a situation, and he may take his mind off of the driving for just a second, and none of this would have any relevance. We would simply say he has not met the standard of reasonable care. But there are many activities where calculated risks are taken, and when this sort of analysis may make sense, and you can see many examples of that in the cases in your textbook.